So first of all, a bit of background, why this regulation and why in particular this is a horizontal regulation. This comes from the consideration that AI systems share a number of functionalities and characteristics that make them somewhat peculiar compared to other software systems. Those are linked to their complexity, their opacity, the fact that being probabilistic, they don't always lead to predictable outcomes, the fact that they can perform with a high degree of autonomy, and they depend on data. So data is an essential component of the functioning of the AI systems. These characteristics lead to a number of risks. Primarily, there are safety risks, which are typically those risks that are already covered by a number of EU legal acts, notably in relation to products, but also fundamental rights risks. I mean, I'm sure you're all familiar with the risk around discrimination, for instance, but also others. And at the same time, there are a number of challenges that they create in terms of, for instance, of enforcing existing law, like, for instance, fundamental rights law or consumer protection law or even product safety law. So this leads to some legal uncertainty. And this legal uncertainty actually is connected with the risk of societal mistrust. So the Commission believes that one of the main risks is that these technologies may not be used because people don't actually trust them. And they don't trust them if, of course, they feel their rights are infringed, they don't have enough remedies, and so on. And so in the case of societal mistrust, there is also a risk that member states will start themselves introducing regulatory measures to address those challenges, leading to, of course, a fragmentation in the internal market. So that's why, because all these challenges are also relevant across sectors. So as you know, AI is often described as a general purpose technology that can apply to any economic and social activity. And so it was important from our perspective to propose a regulatory approach that would be horizontal. So how would this look like? In terms of, so given the challenges that I just described, we felt it was important to have a somewhat articulated approach to proposing a regulation on artificial intelligence. This approach should be somewhat make a number of core choices which need to be unique and somewhat consistent across the board, such as, for instance, the definition of AI, the legal qualification of AI systems, the classification of those systems as high risk, the type of requirements and obligations that apply to those systems, the enforcement system, both ex ante, so before those systems are put on the market, and ex post, regulatory sandboxes, that's actually an innovative element we are introducing, and also the governance system. So if you think that these elements are basically virtually impossible to regulate in a consistent manner with the sectoral approach, meaning amending each sectoral legislation. And at the same time, this would have led to really a lot of uncertainty in terms of timing and also divergences, because it's very difficult to maintain a consistent approach when you actually regulate sectorially. At the same time, because, as I just said, AI is a general purpose technology and has to, so the regulation of AI has to interact with a number of legal instruments that already exist, it was important to make sure that this regulation would also be articulated and flexible as much as possible. And here I provide a couple of examples. For instance, the risk classification AI as regards the product is linked to the classification in sectorial product legislation. I'll explain this a bit later. The requirements for high-risk AI systems will be supplemented by standards. So we have adopted a special technique that is well known, is the so-called new legislative framework approach. So that means that for certain products, we don't foresee the direct applicability of the requirements. That's the case of the so-called old approach products, like, for instance, cars. We foresee there a special regime. The ex-ante enforcement, so the so-called ex-ante conformity assessment, will be modulated. So it's not the same for all high-risk AI systems. It can also be flexibly adapted over time by the Commission. And we also try to take into account a number of sector specificities. The ex-post enforcement system is the same. So it's based on the market surveillance regulation, is Regulation 2019-1020, but member states have a lot of independence in terms of choosing the authorities that can perform those tasks. And furthermore, we also foresee a number of mechanisms of collaboration between sectorial authorities. So for instance, like in the financial sector or the law enforcement. So now, what are a number of, so first of all, I'd like to share a number of key regulatory concepts. It's an internal market legislation. So the legal basis is in 114. So it's really classic, if you want, internal market rules for the placing on the market and putting into service of AI systems as products. In that sense, as I mentioned before, it's a new legislative framework legislation, meaning it's pretty much aligned with the vast hierarchy on product safety, which will be joint applied. For instance, in case of AI embedded in a machinery device or in a medical device and so on. There is an exclusion, which is AI developed for military purposes, which doesn't fit with in our view, with the internal market approach. An important element is that you see here the pyramid. This also, actually, we have largely borrowed from the work of the Data Ethics Commission in Germany. It's a risk-based approach. What does it mean? So essentially, I'll dig a bit deeper later, but the higher you go, the stricter the rules. And also, it's important to note that we don't want to regulate the technology as such, so AI systems or artificial intelligence as such, but only concrete use cases, primarily high-risk use cases. And the type of risk we are dealing is, as I mentioned before, is to health, safety, and fundamental rights. Another important element is that we aim this regulation to create a level playing field between EU and non-EU players. As for any product legislations, the rules are the same for everyone, independent of whether they are internal market producers or from third countries. So how do we define artificial intelligence? You see here on the right-hand side, what is the definition contained in the regulation. This is largely inspired from the OECD. We think that the OECD definition has already seen a large consensus internationally. And so we thought it's a good basis to provide a definition in the legal act with some adjustment. The goal here is to have a definition that is as neutral as possible. So the idea is to cover also possibly in the future techniques which are not yet known, but maybe developed in the future. We also want to cover AI not just in terms of machine learning, but also in terms of symbolic AI and hybrid systems. And a particular feature we have introduced, unlike, for instance, the OECD, we have added an annex with a list of techniques and approaches which needs to be read in conjunction with the definition. And we think this will provide more legal certainty in terms of the actual systems that will be covered. This annex one we propose should be adapted by the Commission over time through delegated acts. I mentioned before, so the pyramid and the risk-based approach. So essentially here we have 4 categories of risks, so to say, but they're not actually, they should not be seen in a linear form because there may be overlaps. So essentially starting from the top, we have forms of unacceptable risk. We have going down the high risk category, which is actually the bulk of the rules of the regulation applied to high risk. Then we have situations where we think there may be transparency risks that should be dealt with by just transparency obligations. And these are not mutually exclusive. So there may be an overlap between situations where we have a transparency risk and a high risk. And then situations where there are minimal no risk, so no essentially further rules. I'll discuss briefly each of them in the next few slides. starting from the bottom, so the minimal no risk or so-called transparency risk or other risks. So we think that most AI systems will not be a risk. In fact, we estimate in the impact assessment that only about 10% of the high-risk AI systems will probably be captured by this regulation. When it comes to those AI systems that present minimal or no risk, we don't foresee any mandatory obligations. We only foresee the possibility for the Commission and the Board to encourage drawing up code of conduct. So that would be purely voluntary. It could be about the application of the requirements for high-risk AI systems to AI systems that are, present minimal or no risk, or it could also be the application of other requirements that are not the same as those for high-risk AI systems. For instance, in terms of environmental sustainability or social sustainability. When it comes to the applications that pose transparency risk, we foresee three categories. One is, the first one is about essentially the so-called chat box. So we think that humans should be notified if they're interacting with an AI systems, unless this is of course evident from the circumstances. The second category is about the emotion recognition system or biometric categorization systems, where also we think that humans exposed to those systems should be notified so that they can, if they so wish, to decide to opt out. Bearing in mind, however, that to the extent those systems are used in a high-risk scenario, they will be subject to the high-risk rules. And finally, the third category is about the deep fakes, so fake content generated by AI systems, which should also be labeled so as a fake content. Now, the high risk is in fact the bulk of the regulation, as I mentioned. And here we, in terms of what is high risk, we have created two main areas, two main categories. The first is the high-risk AI systems that are safety components of products. So here I mentioned before, EU law has already a number of legal acts regulating products like medical devices, machinery, cars, and so on. We foresee that the high-risk AI systems that constitute a safety components of those products the AI systems that are safety components of those products are high risk if the product itself is subject to a third-party assessment under the relevant sectoral legislation. So we have to first see if a certain machinery product or a medical device product, or a toy, whatever, is subject to a third-party conformity assessment. In the case those products include a high-risk AI system which serves a safety function, then the AI systems will be high risk and will thus be subject to the regulation. As regards other AI systems that are not related to products, we call them standalone, but in fact, they could also be somewhat embedded in some products to the extent they're not regulated, those products already. We define a number of areas. These areas are established in Annex 3, and within each area, there are a list of specific AI systems which are explicitly mentioned. We propose that those areas in the area, you see them in the screen, those areas should be set by the legislator, so the Council and the Parliament. Of course, the legislator will also establish within each of this area the high-risk use cases, but we also propose that because we are dealing with a highly dynamic technology, so use cases may change quickly, we propose that the Commission has the power to add, if necessary in the future, new use cases. If an AI system is high risk, according to the classification I just described, what happens? A number of requirements will apply. So Title 3, Chapter 2 foresees that these systems need to comply with 5 requirements before they are put on the market. Those requirements are related to the training, validation, and testing data sets, As you all know, the data is extremely important for the performance of AI systems, so they need to be of high quality. Those systems need to also be properly documented, and they need to have capabilities to ensure traceability. So essentially, event recorders and logging. It's also important that those systems are transparent and that the users are provided with accurate information about the capabilities and limitations of the systems and how to use it. They should also be designed in such a way that human oversight is possible. So this means that some measures may be built into the system itself by the developer, but other measures need to be taken or implemented, I should say, by the operator of the system. And so the operator of the system needs to be indeed informed how he or she should implement human oversight. Finally, the system should be robust, accurate, and also secure against malicious or third-party attacks. These requirements are largely inspired by the work of the high-level expert group, which advised the Commission until, I think, 2020. Generally, you know, collects, there's a large consensus on the importance of these requirements. I wanted also to highlight the fact that these requirements need to be implemented by the providers after setting up a risk management system, which is a common practice in product legislation. And at the same time, those requirements need to be implemented, taking into account the intended purpose of the AI system. Again, the concept of intended purpose of an AI system, of the product, is a key element in the way product legislation functions. In addition, so here, once the product complies with the requirements and can be put on the market after a CE marking. So you may be, I'm sure you're familiar with the CE marking concept, which is one of probably the most known feature of our internal market systems that has enabled trust and free circulation of products among the member states. So we are going to apply the same system also for AI systems. And this is a bit the approach, so how that it works. First of all, a producer of AI system needs to determine whether its AI system is classified as high risk based on the rules that I explained before. Then it needs to ensure through the proper design and development that the AI system complies with the requirements of the AI regulations, the ones I just described. And then the provider needs to ensure conformity assessment according to the applicable conformity assessment procedure, which we foresee there are essentially two categories: a third-party assessment for certain systems and a self-assessment. Once the procedure is completed, it can affix a CE marking, and the product, the AI system, can be placed on the market or put into service. Now, we also foresee, as is classic again in product legislation, a number of obligations for operators. Notably, I just want to briefly highlight the obligations for two categories. There are only just two, there are more, but these are the most important. The provider obligations. So the provider needs to establish and implement a quality management system in its organization, needs to register these standalone AI systems in a new database to ensure broader knowledge and transparency, needs to conduct a post-market monitoring. So basically, once the system has been put on the market, he has to ensure that the system, he shouldn't just forget about the system. The system should somewhat be monitored with the collaboration of the users. And the provider needs to collaborate with the market surveillance authorities in case of investigation and inquiries. The user also has a number of obligations. It needs to use the system and operate in accordance with instructions of use. As I mentioned before, need to implement human oversight measures when using the system, monitor the operation for possible risk, and inform accordingly the provider. As well, inform the provider in case there are incidents or serious malfunctioning. And of course, the user will have to comply with all other existing legal obligations, like, for instance, GDPR. Now, as regards the so-called unacceptable risk, we foresee this category as so prohibited AI practice as residual or minimal. That's why we really think this is the tip of the pyramid. We have foreseen 4 categories. I'll briefly mention them. So the first 2 are linked to forms of manipulation, which may result from use of subliminal techniques or the exploitation of specific vulnerabilities, to the extent this result in physical or psychological harm. The third category is about the social scoring by public authorities. You're familiar with the concept of social scoring in China. This is often called. That's a bit the situation we are tackling there. And the fourth one is the real-time remote biometric identification for law enforcement purposes in public accessible spaces. Here, it's the only prohibition for which we foresee exceptions. And I'll explain a bit more on this fourth category here. So you have to consider that real-time remote biometric identification systems are classified as high-risk AI systems. So you see on the right-hand side, the pyramid with reference to the high risk, which means that those systems need to undergo an ex-ante third-party conformity assessment before they're putting on the market. So if I'm a producer of facial recognition systems that could be used, whether independently, by the police or even by a private operator, because those systems are listed in Annex 3, they need to undergo an ex-ante third-party conformity assessment. There are also additional requirements, for instance, for logging that are a bit enhanced, and the so-called 4 eyes principles for human oversight. But when it comes to the use of those systems by the law enforcement or for law enforcement purposes, the regulation foresees indeed a prohibition in Article 5, but with exception. So those systems may be used only in 3 situations, which relate to the search of victims of crime, threats to life or physical integrity of terrorism, and in case of serious crime. Furthermore, it's also important to note that these systems may not be used for law enforcement purposes unless they have been so the use has been previously authorized by a judicial authority or an independent administrative bodies. So this means that for the use of real-time and post, so not in real time essentially, remote biometric identification systems, no other rules will apply in other situations. So existing data protection rules remain, in our view, sufficient. Moving on, we foresee a number of rules, provisions to support innovations. Here I mentioned before the regulatory sandboxes in Article 53 and 54. So we establish a framework for national authorities to set up regulatory sandboxing scheme, possibly even cross-border. We would like this to adhere to common principle and criteria and set up mechanisms for cooperation between the member states and also the future AI board to ensure there is a common approach. One particular feature of the regulatory sandboxes is that they do not foresee derogation to existing law, but we foresee the possibility for companies participating in regulatory sandboxes to further processing of personal data in the public interest. Essentially, we foresee a specific specification, if you want, of certain provisions of GDPR. Furthermore, we would like to support SMEs and startups by providing access to those regulatory sandbox. We also consider the specific, scale of certain SMEs and startups in terms of their dimensions. And so we foresee certain lighter obligations for conformity assessment fees, for instance, or other obligations like the quality management system. And another feature is that, so we foresee this system to work in the future with the support of harmonized technical standards. So this is a concept that will be key in the future is absolutely common in new legislative framework legislation. And one of the key advantages of harmonized technical standards is that they will help demonstrate compliance by anyone, but in particular by small providers who have less tools, less resources to develop their own technical standards. This is the last slide, is about the governance structure. Briefly, we think that the major obligations, the enforcement of this legislation will be at national level. So we foresee that the member states should establish national competent authorities, including one national supervisory authority. What are these national competent authorities? Essentially, there are two categories. One is the authority that should oversee the functioning of the conformity assessment bodies. These are called notifying authorities. And then we have the authorities that ensure the market surveillance, so ex post, pursuant to the regulation 2019-1020. And as I mentioned, there must also be a national supervisory authority, which is the authority that creates the link between the member states and the European Commission. In fact, we foresee the Artificial Intelligence Board, which will be the European level governance system, which will be composed of all national supervisory authorities and the European Data Protection Supervisor. Why there is the European DPS is because even EU authorities can actually be providers or users of AI systems. So even EU authorities need a market surveillance authority, if you want, and that role will be played by the European Data Protection Supervisor. The Commission will be the secretary of the board. What are the main tasks of the board? We think they should collect and share best practice and expertise, and so contribute to the uniform implementation and administrative practices in the member states. They should also provide advice and opinion and recommendations to the Commission in matters of standards, so I mentioned that, and other technical specifications, and as regards also guidance for the implementation of the regulation. So this is the end of my presentation, and I'll be happy to answer any questions you may have.
Thank you so much for this very inspiring presentation and very exhaustive. Thank you so much. There are a lot of questions in my mind, but I open the floor to the question and in case I come back. So take the floor. So there is a question in the chat. Can you see the chat?
Mm-hmm. Yes. Jesus Salgado can I speak now because I think he made the question.
Yes, if you open the mic.
Hi, hello. So the question is that some high risk and standalone applications may be done without AI techniques. And if that is the case, so simply classic programming development, no? In that case, the developer would not be required to follow the regulation, but it would still, because it's not AI, but the high risk would persist. And I find that there might be, I don't know whether you find the same, there might be a loophole there, and maybe and the other question, if you find there might be a loophole there, how to close it. So imagine an application of I don't know, deep fake, but I can do that with traditional Photoshop, or recruitment, human resources recruitment that I can do without any AI. So this is the case. Thank you.
Shall I answer now?
Yes, please.
Yeah, thank you for the question. I mean, this is a key question indeed, and we have debated extensively at this point. I can tell you that this has been a very clear policy choice for us to focus not on ADM or automated decision-making systems or regulation of software as such, but to focus on AI. Indeed, to make that distinctions between traditional software. It is certainly true what you said, that there may be situations that we classify as a risk in the AI regulation, which could be a risk, even if not using AI. But the reflections were made is that essentially in those situations, you don't necessarily find those characteristics that make the enforcement of existing legislation, the determination of indeed of ascertaining what's happened, what has gone wrong, that we have with AI. So essentially, there are a number of existing EU legislation, and notably here I should refer to GDPR, where, for instance, you mentioned the recruiting system. Certainly, a recruiting system would process personal data. So the GDPR there provides the user of a number of tools which certainly can be activated to ensure information and redress. And of course, the same tools also apply in the case of AI system. But the problem is that with the AI system, often the user doesn't even know how it works. So what this regulation does is ensuring, if you want, that GDPR can actually also be properly applied when AI is used. But we think that when AI is not used, certainly GDPR would be able to address the risks that this regulation doesn't address.
There is another question from Professor Pompeu Casanovas. I ask to take the floor for the question. Ciao, Pompeu.
Ciao, ciao. Thank you very much. And Gabriele, thank you very much. It has been very, very clear. And I would like to ask you to share these slides if possible, because they are quite useful, if it's possible. And I have a question that actually is a practical problem, because I have been developing 2 or 3 or 4 projects in the security area. So what you said is spot on what we have to do now, because we are finishing one of the projects with the police, with the British police, by the way. So when you mention judicial authorities, or when you mention administrative bodies, what kind of instrument can link the restrictions that you are putting on this regulation with the product evaluation of the product? For instance, when you think of an administrative independent body, what kind of body? Where? At the national level, at the European level, where it will be located, and what kind of instrument? Certification, and what is the procedure to do that? I see lots of problems coming from the market, the global market. I'm not thinking on of Europe only. I'm based in Australia right now, and Louis has been developed projects as well. He led a project on security, by the way. So and the rules are very, very different. So no constraints, no supervision from this kind of body. So I think that in a way this is new, and the instruments to make the link between the supervision and the allowance of this product in the market and the general legislation has to be solved. If you tell people, well, judges will decide what kind of court, where, at what level, in Europe, in national members, so members of the state, the state members of the European Union, and what about, well, my case, what about UK, when the product is shared by people IP in Europe and UK, which is the case. So lots of problems. I think I can foresee lots of problems, good things as well. So I can see that this is positive, because this is something like a framework, but this is an unsolved or undeveloped framework, I would say. So can you comment on what I just said? Thank you.
Yes, thanks a lot, Pompeo, for the question. I mean, as you've realized, this is a highly sensitive and politically debated issue, and of course you may see that also in the drafting of the regulation. This has been a really difficult process. What I can tell you is that indeed it may not sound fully fledged, but that perhaps reflects a bit the complexity of the process. But certainly this authorization system should be a national level. So that is what we foresee, that it's true, you know, who should decide whether it's administrative authority or a judicial authority. This should be decided at national level. So essentially here, this is a regulation, but there are, you know, legally speaking, I'm a lawyer, so I cannot deny the reality that this is a provision that probably would fit more a directive. But essentially, the regulation here foresees the member states to take the lead and decide among themselves. And we think indeed that this regulation is also, so one of looking at the positive side, while it's true that this may be complex to implement, at the same time, right now we have a situation where the use of those systems, there is a large legal uncertainty regarding the use of those systems, which are currently right now only regulated by the Law Enforcement Directive. And the Law Enforcement Directive is implemented by member states very differently. So one of the advantages that we heard even from the law enforcement community is that by establishing this clear framework when those systems can be used, this already puts a number of common conditions across the board. Because right now, for instance, in Italy, I've seen recently that the Data Protection Authority has denied an authorization to the Italian police to use a real-time remote biometric identification system because there is no legal basis in the Italian legal system. So the implementation of the Law Enforcement Directive. So in fact, these provisions are the only ones that are based on Article 16. They essentially complement or are a lex specialis to Article 16 of the LED. So I know this may not be the answer you were looking for, but it's a bit short, but hopefully that gives you a flavor.
Oh, it helps. Thank you.
Thank you so much for the answer. We have a lot of questions, but the time is very strict and tight. So there is the last very brief question from Giorgia Bincoletto, please.
Thank you for your presentation and for the opportunity to ask a question. You mentioned in the beginning of your presentation that the regulation medical devices remain safe and it will remain lex specialis. But do you think that the standardization process and the certification process that is required, for example, for an app that has the function of telemonitoring with AI system inside, or for digital therapeutics that are the future of telemedicine and e-health, do you think that this the certification processes of the future AI Act and of the medical device regulation should be coordinated in a way also at regulatory level, or they should be separate as you wrote in the proposal?
Yes, thank you. I think this goes back a bit to the origin of the regulation. Why did we decide to do a horizontal regulation versus a sectorial? What you're suggesting is a bit the sectorial approach. We could have amended each sectorial legislation, the machinery, the medical devices, and introduce the same requirements a bit everywhere. Or we could have decided the other way, so have this horizontal approach. You have to bear in mind when it comes, and this is why we foresee a differentiated approach between new legislative framework products and old approach products. So new legislative framework products, and this is those products that are covered by indeed, so the system of harmonization, European harmonization system, primarily medical devices, but not only. I mean, there are quite a number. Those systems can be combined. Even today, if you take a medical device that is a radio equipment, but most medical devices can also be connected, most of them. So the manufacturer has to comply at the same time with the radio equipment directive and the medical device regulation. If you build a toy that is also connected, they have to comply with both. So one advantage that we realize we should use of the NLF approach is that these systems can be combined. And so by introducing a horizontal approach on AI as an NLF system, we use the same methodology. So we allow manufacturers of machinery, of medical devices, of toys, or whatever, any product that may have AI, to combine those two legal acts and to use, importantly, the same procedures. Because what we are foreseeing is that essentially is going to be the conformity assessment body established in sectorial legislation. So in this case, the notified bodies for medical devices to perform the conformity assessment of the product, not only with the medical device regulation, but also with the AI Act.
Okay, thank you so much. We needed to go ahead, but we would like to, in the future, have a new slot for discussing together and to have more questions. So it's a proposal to have a new invitation for you in the next future. And thank you so much for sharing your thoughts and the explanation of the rationale coming from the European Commission about this so important and exciting proposal. Thank you so much.